Around the world right now, class actions is a big topic. Many countries are starting to adopt them for the first time. Many countries are putting into place private mechanisms of legal enforcement where they've never had them before. Much as this has been a feature of American law for a long time, the question is, why do we have this? Why do we have private organizations take up the role that's typically played by the government in protecting collective rights? I was just in Buenos Aires recently at a conference of an international procedural group, and over 500 people turned out to address this question. And the presentation I gave, which is now the basis for a paper that will also appear in Spanish and Italian, was that class actions actually play three different roles with regard to state authority. First, in famous cases like Brown versus Board of Education, it can be a way of organizing the group to legitimately press its claims as outsiders, as what we call discrete and insular minorities, saying that government has failed them, government has not looked out for their welfare properly. Alternatively, class actions in the United States serve as adjuncts or as complements to state authority. The federal government, for example, routinely prosecutes securities claims of fraud or prosecutes antitrust cases against persons who engage in conspiratorial behavior in the markets, but it doesn't have the resources to finish the case, to go and get the last damages, or in many cases even to initiate the conduct by itself. Here, private actors organized in class actions under the supervision of courts finish the job. They serve as aids to the government. The third category is the more complicated one, and that is areas where the government really hasn't taken the initiative and where you have private parties who do the bulk of the work. Consumer cases, some environmental cases, even some civil rights cases against private actors. These are the purview of individual lawyers on behalf of a class action. This is the most controversial area because this is where class actions emerge as, in effect, an alternative or a supplement to state authority. It's here that we see many of the greatest controversies in class action law in the United States. And one of the points I make to an international audience is that this is the source of tremendous resistance and controversy as class action practice spreads around the globe.